The big news in bankruptcy this week comes to us thanks to the federal government. The Justice Department said in a court filing that the Solicitor General will be filing a petition for certiorari in the U.S. Supreme Court asking the High Court to reverse the Second Circuit's Purdue decision. You may recall that at the end of May, the Second Circuit reversed the district court and reinstated confirmation of the Chapter 11 plan for Purdue Pharma. That was a big opioid case where, whether creditors liked it or not, who held mass tort opioid claims, the settlement was going to be imposed on them even if they didn't want it. Well, the Supreme Court, as I said, is now going to receive, by the end of August, a petition for certiorari. This does not mean that the Supreme Court will take the case. Rather, the Supreme Court has the option of taking the case or not. But I'll tell you this, if the Supreme Court decides to grant certiorari, what they're going to be doing is resolving an important split of circuits. Because, as you can see, the Second Circuit says that it's perfectly permissible in Chapter 11 to issue these third-party non-debtor releases. On the other hand, you have the Fifth Circuit, the Ninth Circuit, and the Tenth Circuit, which all categorically hold that those kinds of non-consensual releases are beyond the power of a bankruptcy court to issue. So, not only will there be a resolution of the circuit split, but I think this is going to be the most important bankruptcy decision to come down from the Supreme Court since the Stern versus Marshall decision in the year 2011. Well, why is it important? Well, first off, if the Supreme Court says no, bankruptcy courts don't have the power to give these non-consensual releases, I'm not sure that's going to be such a big deal, because in Houston, Texas, which is in the Fifth Circuit and cannot issue any non-debtor releases, that's not affecting their practice whatsoever. Indeed, Houston is now the single most popular venue for filing major Chapter 11 cases. So I think companies are going to have a way to determine a workaround, even if they can't use these non-consensual releases. On the other hand, if the Supreme Court sides with the Second Circuit and says that non-consensual releases are perfectly permissible, then the floodgates will open, and all around the country we're going to have large, profitable, solvent companies using various machinations to get subsidiaries into Chapter 11 and dispose of all of their tort liability. Well, this, as you can see, is a really big deal. The timing is going to go something like this. The Justice Department, as I said, through the Solicitor General, will file the petition for certiorari before the end of August. Probably a month to 2 months later, the company itself will file its response and argue that no, the Supreme Court should not hear the case. Doubtless there are going to be dozens, if not hundreds, of amicus briefs on both sides telling the justices they either should or should not hear the case. I think sometime in the fall, as early as the first week of October, but probably more like into November, the Supreme Court is going to decide whether or not to take the case. Of course, as you can see, the Supreme Court already knows that the Solicitor General wants the case in the Supreme Court, so there will not be a delay occasioned by asking the government whether the court should hear the case. It thus looks to me like, sometime November, December, we're going to have a decision on whether the court will take this big case, and if they do, argument will be held sometime in the winter, and we will have a decision from the Supreme Court, I'm guessing sometime between April and June of 2024. I am Bill Rochelle, the Editor-at-Large for American Bankruptcy Institute. I will return same time next week with something important from the world of bankruptcy, but I don't think we're going to have anything next week as important as this petition for certiorari. Thank you and good day.